Regents Professor and Chair of the Consortium on Law and Values in Health, Environment, and the Life Sciences at the University of Minnesota. The topic today is one that she is particularly well suited to address. I said a moment ago that Professor Wolf was was a Regents Professor, but she, as a Summa graduate of Princeton and of the Yale Law School, is more than that. She is also Professor of Medicine. She's the Baker Daniels Professor of Law and the McKnight Professor of Law, Medicine, and Public Policy. That's quite a few professorships to carry around, Professor Wolf. And over her tenure at Minnesota, she's held many additional academic chairs. She's the founding director of the Joint Program in Law, Science, and Technology and serves as the faculty chair of the law school's concentration on health law and bioethics. She's an elected member of the National Academy of Medicine. She's an elected fellow of the American Association for the Advancement of Science and an elected fellow of the Hastings Center, and elected as a member of the American Law Institute. Her research has been supported by NSF and NIH and the Greenwald Foundation. And from 2011 to 2016, she served on the National Science Advisory Board for Biosecurity, and she currently sits on the National Academies Committee on Science, Engineering, Medicine, and Public Policy. She'll be speaking today on this topic of research results being returned to individuals, which was something that was for many years not done because the results were not considered clinically actionable. The revolution that's occurred in the past decade in clinical research includes routine consideration of returning such results and findings. And she'll address the current state of this transformation and the ongoing debates, as well as the central role of return of results in translational science. By the end of this forum, participants will be able to describe the evolution of guidance on the return of results and incidental or secondary findings, analyze the ongoing debates, and identify the role of return of results in translational science. So it's my pleasure now to turn things over to Professor Wolf. I want to ask you now to please fill out the evaluation form you'll receive from the CTSI, and there'll be more information about that at the end. And so, Professor Wolf, the floor is yours. Welcome to USC.
Thank you, Alex. It's a great pleasure to be with you today, even if only by Zoom. I wish I were really in Los Angeles. Not only because for these many years, I've always loved collaborating with you, Alex, as you know, but also because I should disclose, I am a USC parent. My student graduated in June, but he issued a red alert today that USC plays UCLA this weekend. So I think I am obligated to say, fight on. All right. With that, let me share my screen and get my slides up. I want to talk with you about a debate that I've been a big part of, return of results and incidental or secondary findings that has really resulted in a sea change in how we think about the conduct of research. There was a front page article in 2012, the New York Times, quoting Director Francis Collins at NIH, who identified return of results as one of the thorniest challenges in clinical research. It's really risen to that level. It's prompted an outpouring of research, scholarship, a report from the then Presidential Commission on Bioethics in 2013, another report in 2018 that I'm going to talk about in a few minutes from the National Academies of Science, Engineering, and Medicine. And it even features in the revision of the Common Rule that went into effect around 2018. Data have long supported the conclusion that most research participants, if you ask them, say yes, they want to know about their individual research results. But as Alex pointed out, that's not been the history. The custom has been not to offer research participants their own results. That's a custom that's rapidly changing, as witnessed by the federal All of Us research program, which features return of results, individual results to the participants in that large 1 million+ person federal project out of NIH. At the same time, there's also been a transition in the clinical world. I'm going to focus on genetics and genomics in research and clinical care as a really important sphere in which this transition has happened. And in clinical whole genome sequencing and whole exome sequencing, I'm going to talk about the evolution of policy at the American College of Medical Genetics and Genomics, ACMG. But I just want to note as context that this issue is not at all peculiar to genetics and genomics. If you think about clinical care, the incidental findings problem arises all the time. You know, I may go to my doctor and say, wow, my shoulder is really bothering me. And my, orthopedic surgeon may look at my shoulder, but then her eye drifts up to my neck and says, wow, there's something on your neck. You really ought to have that seen by a dermatologist. It's a standard part of clinical care that you come in for one thing, but your physician astutely or your clinician notices something else. What we're finding is that this is a standard part of research too, depending on how broadly researchers look. And so it comes up in every form of research, basically imaging research, environmental health research. I'm just going to focus on genetics and genomics. So let me give you an overview of the ground I want to cover, and then I'm really looking forward to dialogue with Alex and your questions. I'm going to argue that research routinely, as I've already suggested, generates findings, individual specific findings of potential clinical, reproductive, or broader personal importance. This is just built into the conduct of research. Dealing with it, though, appropriately raises very interesting problems because it ends up challenging a conventional dichotomy that has structured bioethics and health law, a dichotomy between the world of clinical practice and the world of research conduct. So I want to talk about that. This problem of return of results also challenges past approaches to biobank research, which has increasingly become a feature not only of genomic research, but all kinds of research, where we archive data and biospecimens for use way into the future in all sorts of research projects. The consensus is that researchers in biobanks do indeed have duties to return some results. In the clinical sphere, recommendations support return of incidental or secondary findings in genetic analysis. But the core thing I want to argue, particularly because of the CTSI sponsorship of this lecture today, is that this is at core a translational problem. And so I want to pan the camera back at the end and ask you to think with me about whether we need to reconfigure how we think about the relationship between research and clinical care and how we move between those two different spheres translationally. So this is just a quick slide to give you an overview of the funding and the projects that we've done in this sphere. It's quite a few. So let's start with research. Let's get a little more structured first about what we're even talking about. These are definitions drawn from the first project, the first NIH-funded project that I led of several on return of results and incidental findings. In fact, this project that began in 2005 was, to my knowledge, the first project funded by NIH dedicated to the problem of incidental findings. So these are definitions that we developed in that project. First, an incidental finding is a finding concerning an individual research participant, a finding that has potential health or reproductive importance. We might also say now broader personal importance in some cases. It's discovered in the course of doing the research, but it's not what you were funded to study. It's not within the little blue box that symbolizes here the aims of the study, the formal aims that were stated in your research proposal when you got funded. It contrasts with individual research results. Those are findings on the variables you in fact were funded to study, which is why my little cartoon person is now inside the aims rectangle. And both of those contrast with aggregate research results. Those are the normal research results published concerning your research population. What's interesting is that there's bleed among these categories. For example, on one of my projects, I collaborated with folks at the Mayo Clinic. They had a biobank studying pancreatic cancer. They put out a newsletter, as is good practice, to stay in touch with your biospecimen contributors, keep them up to date, what's going on, what are you discovering? And they said in their newsletter, we've discovered a relationship between a new variant and risk of developing pancreatic cancer. Well, one of the participants in that biobank apparently took the newsletter to their doctor, who said, well, contact them, find out, get your individual result. Are you one of the people with that variant? So that was a bleed between aggregate research results all the way up to individual research results. Now, in recent years, a distinction has arisen between incidental findings and secondary findings. Here's a passage excerpted from Kalia et al. In 2017. This is in a sequence of publications as the ACMG has developed their policy on clinical sequencing and return of incidental or secondary findings. Actually, they started calling them incidental findings, but then they came to this distinction saying, well, it's a secondary finding if you purposely look for it. It's not truly incidental in the sense of accidental if you look for it. In truth, people have long used incidental findings to refer to both intentionally sought and stumbled upon findings. In fact, one of the core issues in this area has been, is there a duty to hunt deliberately? But this distinction has become accepted. In fact, I'm going to use the term return of results as an umbrella term, referring to offering a research participant or a patient their own research results, their incidental findings, and or their secondary findings. Okay, so let me foreground what some of the problems have been. First of all, how do you delimit the category of concern? What criteria should be used to define returnable results or secondary findings or incidental findings? Think about something like whole exome sequencing or whole genome sequencing. You're dealing with a fire hose of information up to a person's entire genome. So what subset is the subset that should be considered for offer? And how broadly do you want to think about that offer? Do you only want to think about it in terms of results that could change medical treatment? Or do you want to think about maybe carrier status, findings that won't affect that individual proband's health, but could affect their reproductive decision-making? Maybe even broader findings that won't affect either one. We've seen people call for all of the above. So what criteria are we going to use? Second of all, I've already mentioned, how aggressively should researchers go after these things? Is there a duty to look? What should researchers do once they spot one of these? I mean, it could be perhaps this is a researcher studying cardiomyopathy, but this is a finding that has to do with cancer propensity. The researcher is not an oncologist. Who should they consult? What's the pathway that they need to set up when they're designing their protocol? And by the way, designing the budget to fund their protocol to deal with all this. What should be offered to the research participant? What about to their physician? What about to their family members? If you're holding the data long enough, or depending on the health status of the research participants, maybe a participant loses decisional capacity. Maybe they die. Does the family have some entitlement to learn about findings that may pertain to their own health at that point? And how do you set this up all in advance? At this point, really any responsible IRB should be knowing about this, should be looking for this. In fact, study section will be looking for this at NIH. And finally, what should biobanks and data archives do? Okay, so I want to get straight to the punchline, if you will. Why is this a problem? Why am I calling out the translational nature of this issue? It's because this is intrinsically a bridge problem. So I've got this bridge over the Mississippi River in the upper right. Here in Minneapolis, St. Paul, we straddle the Mississippi River, this iconic divide in the United States. We are talking about discoveries in the research space, on the research side of the river, if you will. And the whole question is, do you give them back to this research participant? Do you somehow communicate them across the river to the clinician because of their potential clinical health or maybe reproductive significance? Is there some kind of handoff that should be undertaken to convey these results from one sphere to another sphere? You begin to get a feeling for why I'm calling this translational, because of course, the whole idea behind translational science is movement from bench science to clinical trials, all the way out to practice, sometimes to population deployment, often with a lot of loops back, that you discover something in the clinical practice or population deployment that calls for further research. So we're talking about the movement of this information across domains. Whoops. Okay, why is that movement an issue? And why am I invoking the Mississippi River, this line that divides our country in half? It's because of what's on this slide. Now, Alex may laugh seeing this slide because I'm trying to compress what's essentially an entire semester, if done properly, into a single slide. But bear with me for a second. On the left half of the slide, so on one side of the river, under the caduceus, I'm trying to outline the rules, the customs in clinical practice. I'm shorthanding it doctor-patient. It could be nurse-patient, clinician-patient, but I'm trying to put it all in one slide. So in that domain, we know that the clinician owes the patient a robust duty of clinical care. the duty is to serve the patient's interest in keeping with that patient's values and preferences. If the patient feels the care breached the standard of care and that breach was causative of harm, compensable and damages, the patient can sue, obtaining retrospective adjudication of fault and liability. I just gave you malpractice law in one sentence. It's largely governed by state tort and contract law, as well as ethics codes we've had for millennia. And there's a lot of guidance, legal, ethical, clinical, on what is the information disclosure duty or set of duties of clinicians. But go under the microscope to the other side of the river. It's a really different picture. Here, conventionally, the researcher's core duty is to seek generalizable knowledge. It is not to take care of this patient. Now, there are obligations to limit risk and harm. That's a lot of what IRBs take a look at, the balance of risk and potential benefits, if any. But the core name of the game is seeking aggregate benefit through pursuit of generalizable knowledge. And participants who've been injured in research have traditionally had a very tough time suing anybody and getting any compensation for it. It is just totally different. The governing rules, particularly in federal research or in institutions like my own that apply the federal rules broadly, it's the common rule and the DHHS parts that follow the common rule, the FDA rules on human subjects research, and ethics codes to govern research. Formal ethics codes are very, very recent. They really grow out of the Nuremberg trials of the Nazi physicians and the Nuremberg Code, something Alex is deeply expert upon. And Alex has spoken in this shop on that issue. And so this question that we're talking about today, which is what is the duty to disclose information, is much less settled. We know much less about it. Okay, why do we have this dichotomy? Well, in essence, we've conventionally seen research as narrow, pursuing circumscribed questions, not, lifelong healthcare for your entire body and self. Researchers are seen as advancing aggregate knowledge, research conventionally as time limited, and as an activity that's not always tethered to clinical settings. But the newer research realities have challenged all of that as we've moved from the language and hopefully the attitude signaled by that language of research subject to research participant, a much more respectful and egalitarian vision of the relationship, the partnership, the rise of community-based participatory research, and development of a much more robust set of duties to research participants that sometimes, in part depending on what part of the world you're in, fall under the rubrics of solidarity, trust. And we've seen lawsuits for breaches of trust. And so ethics theories have emerged to cope with these realities, including ethics theories supporting the transition we're talking about today, to the idea of the need not to sit on information that you've got that really may be of high health importance to this research participant, but to share it. So Henry Richardson and Leah Belsky have written about what they call the duty of ancillary care, not arguing that researchers are like full-blown physicians under that caduceus, but saying, nor are they mere scientists who can just sit on that information, whatever the consequences to the participant. Judy Illes et al. Have talked about a duty of reciprocity. And an article I think is very important, Zach Kohani at Harvard and others have talked about the problem that, in their view, withholding data like that makes research participants what they call passive purveyors of biomaterials and data. It really is not treating them as research partners. So growing out of this, we have had, based at Minnesota, but with with collaborators all over the country, a series of consensus projects. This summarizes the conclusions of 2 of them, that researchers do shoulder duties to manage incidental or secondary findings and individual research results. They should plan this all in advance. When you don't want to be dealing with this is you're halfway through a research project and suddenly you're staring at an individual's finding with no pathway created and it's of urgent potential medical importance. It all needs to be planned. And we kind of trifurcated the space into should return, may return, and don't return. And you see on this slide some of the features of should return: analytically valid, established and substantial risk. We're talking about a serious health condition, actionable, and this becomes important in a second. The research participant consents to the receipt of this information. This is not about inflicting information. It's about offering. May return, discretionary return. We, in these consensus projects, there we're talking about established and substantial risk of likely, but not as dire results and not as threatening results. And we did say that biobanks indeed needed to switch gears. Let me talk about that for a second. Whoops, I don't know why this keeps popping up. There we go. This is a cartoon that is a schematic of only one way in which biobanks can be organized. They can be organized in all sorts of ways. This is indebted to a depiction that used to live on the National Cancer Institute website, where you see in stage 1 at multiple sites, researchers doing their research. They may be collecting biospecimens and data and feeding it into this mothership, this hexagon at stage 2, the biobank, which, if it's any good, is doing quality control, reanalyzing the specimens and making sure they're analyzed and classified correctly, maybe conducting research in the mothership and supplying the stage 3 sites. And returnable results and incidental or secondary findings can arise at all 3 stages along the path. An example at stage 2 is what's called discrepant diagnosis. Let's say a stage 1 research site sends a specimen to the biobank saying this is a certain kind of leukemia, and the very wonderful pathologists in the biobank say, no, it's not. You then have a real problem because you've got a research participant or patient out at a stage 1 site being treated for a leukemia that the pathologists in the biobank say the person doesn't have, there's something else. So that's just one example of where this issue can arise, and the question of who is going to contact this person and how becomes very important. So there's been an evolution of thinking in biobanks from forget it, we're not funded to do this, we're not organized to do this, to I think we better do this if we can. And so the All of Us research program is embarking on this, the UK Biobank, all of this with limits. And there's a great new article, I wanted that you see the site for it, the bottom of the screen. I want to commend you from the Mass General Brigham Biobank, which in great detail in the American Journal of Human Genetics is just coming out now, talks about a protocol that they have developed. I want to very briefly touch on return of results to relatives. We did a funded project on this. This was the one that was collaborative with Mayo, also with UCSF. And the core problem really is in the second bullet, that US law and research rules focus on individuals, individual rights, individual protections. But as you know, genetics isn't really about individuals. It's about kin groups. So it's very easy to discover something about my genetics that may have serious implications for my family members. But there has been in the past very little planning about how to deal with family queries or who should get these results after the incapacity or death of the research participant. So we tackled this. the launching pad, I'm going to go quickly through this. We can certainly come back to it if it comes up in the questions, is that there's been a very long conversation in clinical genetics about duties to family. Because even when a clinician says to a proband, you have this gene or this variant, and these are the implications for your family, I'd really urge you to broach it with your family members. There are going to be some patients who say, I don't want to, for any number of reasons. I don't want to do it. And so quite early, and in some lawsuits, family members protested that perhaps the clinician had a direct duty to them to offer these results. After a lot of work, the dominant conclusion is that the clinician's duty is to their patient, including maintaining the confidentiality of the information, and that only in quite exceptional circumstances where the harm is serious, imminent, the patient absolutely refuses to warn their relative, and prevention or treatment is available. So warning is indeed likely to avert serious harm. Is there any privilege to, not duty, but privilege for the clinician to breach confidentiality and reach out? So that's in clinical care. So we were looking at this in research. We were aware that relatives under Hipaa rules and in some states, state law, already had some access to a person's research results, including after death, depending on who the personal representative, that's a Hipaa term. When I die, Hipaa continues to protect my PHI for 50 years after my death, but my personal representative, which is defined by state law, is in charge of that PHI. So that may be a family member, they may get access and they'll make the decisions about sharing. We ended up recommending that indeed, particularly when a research project was collecting data and or biospecimens that would be saved and analyzed for an extended period of time, this problem should be anticipated with participants asked their preferences on sharing, including after death. And we went on to basically encourage support for the personal representative discharging their duties, but recognizing a rare exceptional case where researchers may be warranted in considering a direct outreach to family. The last thing I want to do here before we go to clinical care is talk about the National Academies report, just very briefly in 2018. This was an important report with a lot of good in it, but also raising some concerns. And you see a little picture of the cover of that report. That report said, this is coming, it's on board, routinely consider return of results. Some of the problems, however, in the report's analyses and recommendations are that in some ways they suggested shutting down some return of results. It was ironic. On the one hand, they're saying it's good, it's coming, expect it, plan for it. On the other hand, they were very worried about the quality of results being returned because these are research results, not clinical results. So they tried to create boundaries and reassurances. They said, well, only return if it's from a laboratory, a CLIA lab. So CLIA, as you know, is a statute that applies to clinical laboratories that helps assure the quality and reliability of their results, or labs that are certified under a quality management system that NIH should put together, but it hasn't put together yet, or IRB gives its approval. All of that is much narrower than what really currently exists. And in fact, Barbara Evans and I published a couple pieces in Science, as well as a long law review piece, arguing that the report misunderstands CLIA and misunderstands the relationship between CLIA and Hipaa. And that in fact, if you look at the second bullet, there already are 3 established pathways for returning results to individuals. First, those results may be generated in a CLIA lab. Some research projects use a CLIA lab. Second, the researchers may take on the responsibility of confirming a research result in a CLIA lab if it's being considered for return. But thirdly, and the report actually acknowledges this at a few points, researchers, in our view, can offer back to research participants non-CLIA results with all the warning signs flashing. Non-CLIA results don't make clinical decisions. These are being conveyed to you for the purpose of your working with your clinician to seek clinical confirmation and evaluation in the context of a clinical workup. So just to give you a flavor of that ongoing debate. Okay, all of that's in research. Let's do a quick pass at clinical care. And here what I want to focus on is this evolving story that involves the American College of Medical Genetics and Genomics that I alluded to before. So 2012, ACMG comes out with a policy statement, very solid. It says, look, we as a community have launched into the world of whole genome, whole exome sequencing. Once you're collecting data on that scale from an individual, it's almost inevitable that you're going to find in every single one of them some kind of incidental finding. And so it said, full stop, labs, clinics, you need policies on, are you going to disclose this? Are you going to disclose a subset? You need to share the policy, and you need to talk to people before the testing so they know what to expect. And you need to let them to say no. You need to let them opt out of receiving some of these incidental findings. Then the plot thickens. The very next year, a committee of ACMG says, well, in fact, whenever clinical sequencing is undertaken for any indication, maybe a patient has cancer and they're no longer responding to conventional treatment and you're looking for a new molecular target, or you've got a child with a puzzling neurodevelopmental anomaly and conventional testing has not yielded a diagnosis. There are all sorts of scenarios. Whenever, regardless of indication, the laboratory should look for 56 extra genes. And this is without consent from the individual. If the patient doesn't like this, they can decline the whole sequencing altogether. The clinician then shares the results with the patient. And if you look at that bottom bullet, the report was forthright and said that they did not favor offering the patient a preference as to whether or not to receive this 56, this list of 56, and that this may be seen to violate existing ethical norms regarding autonomy and the right not to know. Well, yes. In fact, yes. And a firestorm ensued. This is just the tip of the iceberg here. I participated in this firestorm. To ACMG's great credit, they revised. Very next year, they said, we've rethought and there should be an opt-out. Still unresolved, however, is can patients elect analysis of some extra genes and not others, or is it an opt-out of the whole menu? And there are two other issues I want to highlight, pediatric and updates. On kids, this is really a continuing problem because the ACMG framework has said it makes no difference whether you're talking about a child or an adult, but there's a very long-standing consensus from multiple organizations that it does make a difference, that genetic testing in minors should be restricted to what's medically needed while they're still a minor. If you're talking about adult onset or results they don't need as a minor, you should preserve their choice and wait till they achieve the age of majority at 18. And whether it's at 18 or 28 or 38 or never, it's up to them. whether they undergo that testing. ACMG on various grounds has rejected that traditional logic, and it remains a very big source of debate. The other debate, which is more emerging right now, is how to handle updates. So ACMG came up with this list of 56 in 2013. In 2017, CLIA et al., it was 59. Earlier this year, it's up to 73. So you see it's a moving target with these updates. And it raises the obvious question. If a lab has already issued its report and the communication on the 56 has already happened, but you're still in the research project, or the patient is still under your care, and now we're up to 73, do you need a new lab report? This is part of a much broader issue about reinterpretation of and recontact, and there is no gelled consensus on this. So in Miller et al., they said earlier this year, labs should not be expected to revise clinical reports that they've issued that were based on an earlier version. But if you look at the bottom half of the slide, there is guidance to the contrary. So various organizations have weighed in on this. The American Society of Human Genetics, even in research, has strongly recommended trying to recontact the participant if you've got a reinterpretation and you think it is expected to affect medical management. And ACMG itself in 2019 talked about a laboratory duty to at least tell the ordering doc of the original test if there's been a variant reclassification, and then talked about the physician taking reasonable steps to try and recontact the patient. So this is a very unsettled area. Okay, the last little bit of what I want to do, pan that camera out and look at this translationally. This is one of a trillion cartoons of the translational process that you all probably know. From time 0, time 1, 2, 3, 4. And basically, it's one of many depictions of the process from bench discovery through clinical trials, through clinical application, what they call practice here, population health, with a lot of interaction going on in the middle. Where does return of results fit into all of this? I, with colleagues, have argued in a couple publications that it plays actually a very important role in translational genomics. Return of results is an intrinsically translational process. Remember that handoff across the bridge. It's about moving information from one sphere to another. The National Academies in 2018, that was part of their worry. It's like, oh no, you've got research quality information and you're trying to take it across the bridge to clinical land, but we're worried that it's still research quality information. That's a translational concern. So done right, return of results is an opportunity to pioneer recognizing in the world of genetics and genomics important variants that need to be communicated. We're learning more about them. We think they may affect clinical management, be actionable, and it becomes a way to pave the road into clinical practices that deal appropriately with that gene or variant as we learn more about it. It creates a translational pathway based on evidence that you're still accumulating. All right, so conclusion. I hope I've suggested that the problem of return of results and incidental or secondary findings, it is ubiquitous. It cuts across research, biobanking, clinical care, and I haven't even talked about population screening. In research, it is this very interesting bridge problem that challenges the conventional architectural dichotomy in health law and bioethics between research and clinical care. It's a problem in biobanks, but we're seeing biobanks rise to the occasion. In the clinical world, I think we're making progress, but as you can see, we still have some unresolved debates going on. Ultimately, I think really wrapping our heads around return of results requires thinking translationally. And the core challenge across all of these domains is, how do you advance science and biomedicine and good clinical care, and at the same time respect the needs and choices, including choices about what information to receive, the choices of research participants and patients. And with that, I will stop sharing my screen.
Thank you very much, Susan. That was clearly an example of why we need the newly passed infrastructure bill, so that we can have the bridges in medicine just as we are repairing the bridges on our highways. So the first question that came in, and if we were live, you would know who asked it, so I'll tell you. It is our Vice Dean for Research at the medical school, who's an endocrinologist and works on diabetes. And he began by asking the question of the non-CLIA lab issue, and described what they do. And he said, for example, we have provided glucose values from our research teams to patients with a caveat that they were obtained from research lab and should be shared with the patient's participants provider for any decisions about clinical care. So he was very pleased. That was right before you got to that point in your talk. So he was saying, I'm glad to know we were doing that correctly. But then he raises a second question. What if the result has no meaning in clinical care? For example, a measure of insulin sensitivity obtained through a research procedure never applied in clinical medicine. Such measures are not broadly standardized, and clinicians have no context in which to interpret the results. And I think that is close to what you were getting to at the end, where you were sort of saying, sort of boldly pioneer and lead the way for the clinicians. Do you have a comment on this example or this problem?
Yeah, well, first of all, I am heartened to hear the approach being taken to return of non-CLIA results. I just want to say the obvious, which is I'm not here to give legal advice to anybody. It is my understanding that that is an accepted way of doing things. I've heard a little bit of a spread in what lawyers say to their clients about this, but my interpretation and Barbara's interpretation that we've written about at length is that that is accepted, and in fact, the National Academies report recognizes it. Let me talk about Hipaa for a second, because it's relevant to this question. CLIA is not the only game in town for this question. Under Hipaa, patients have a right to ask for their data, everything in the designated record set. And so many have interpreted that to mean that they could get this glucose measure that was being referenced, for example, if it's in the designated record set, even if it's not understood in a clinical sense. There are lots of reasons people may want results that are not well understood, including that they may want to volunteer for another study. Or in this era of patient-initiated research and citizen science, they may want to participate in some study that's being done even outside of a conventional academic health center. So people do have the right, and in fact, in genetics and genomics, there are participants who've said, give me my whole genome, give me my BAM file, and gotten the hard drive. It's not easy to give people, you can't just like send them a file. So that is a right that already exists. I think without delving deeper into this example, I think participants may want even a result that's not understood for the reasons I've suggested. They can share it with their clinician. The clinician may want to confer with the researchers to understand more deeply what is known and what is not known about that measure, to follow the trajectory of the research, to say to the researchers, loop me in. I need to know as you understand this more deeply. So I think the mere fact that its clinical implications are not fully established doesn't rule it off course, particularly because Hipaa may entitle the participant to the information anyway.
And a further follow-up on that, and by the way, participants can also use the Q&A function as well as the chat function to bring questions forward. What about, what are your thoughts on the distinction between a researcher who is also a clinician and a researcher who is not? And that would be both in ethical terms, perhaps, or in practical terms. If the clinician who's doing the research is the patient's clinician, then obviously the knowledge will be automatically transferred into what is a clinical record as well, because the physician is taking care of that patient. But in the other situation where the researcher is not the clinician, and perhaps not a clinician at all, but some other kind of researcher, a PhD, what about, how is that handoff to be accomplished? So it's a kind of an ethical as well as a practical set of concerns in those different situations.
Well, as you know, Alex, there's a huge literature on the two-hat problem. And our joint mentor, Jay Katz, wrote, among many others, at enormous and perceptive length about the difficulty that ensues when a person's wearing two hats, even though, of course, it's not at all uncommon that it happens. Part of the difficulty is illustrated by your own aside a second ago, Alex, saying, well, of course, if the clinician is also serving as the research result automatically goes into the medical record. In my view, it should not. In my view, that's an example that there of a piece of information where there should be deliberate discussion with the patient about whether we move this into your medical record, because there can be consequences for its being in the medical record. Potential breach of privacy, but also the law, as you know well, Alex, the law, GINA, and other federal law, as well as state law, protecting people from the misuse of genetic and genomic information and discriminatory use is quite imperfect. And so combining the roles invites a kind of forgetting that there's some steps that should be pursued along the way. Part of the reason that I put up the citation to that new article by Blaut-Sawatsky et al. At Mass General Brigham is it has tons of supplemental material showing step by step how they did this transfer of information to participant, to clinician. It's not the only way to do it, but mapping this pathway, there's not one way to do it, is a great question and very important. So I would really, I think, commend that article to everyone.
And just as a reminder to our participants, you will be receiving a link to this talk and the slides so that all those citations that Professor Wolf included in her slides will be available there to you to follow up on. Now we have a genetic counselor who has raised the following. I spend a lot of time with patients discussing the benefits and limitations of genetics and genomics and obtaining informed consent for clinical testing. However, I am interested in what are the best research practices for educating and eliciting preferences from research participants when there is a limited bandwidth or resources in a given project. And I would suggest that one of the interesting things in that question is also the difference between being able to discuss the research results, which are the primary results being sought, versus those incidental findings, which are not in the viewfinder at the moment that you're talking research. And what do you think are the best practices there, alluding to such things and waiting till later to get actual consent, or seeking to have limitations there out of recognition that this is such a wide field that you can't have any detailed consent? What do you think of those?
Well, a couple things. First of all, there's a whole literature on this great and a very important question. And I'd like to add to this question because a lot of clinical genetic counseling, maybe not at USC, because it's such a sophisticated tertiary and quaternary care center, but in many settings is really about genetic testing and isn't equipped to deal with the complexity of genomic sequencing, much less some of what's coming on board like polygenic risk scores. So there are a couple layers to this, being able to counsel about research, but being able to counsel effectively about the actual analytic methodology or methodologies being used in the research sphere. So I think there is a real literature on this. I think Blaud-Sawatzky is herself a genetic counselor. She's the lead author of that article. So that would be a good place, one place to look as well. What they did in that study is a sort of staged process where they consent their biobank participants for recontact. So they don't do, talk about, they were using the ACMG list, I think ACMG 59, not 56 list, but not all the way up to 73 now. So I don't think they didn't go through all of these. They consented for recontact, and then they had a staged process with actual scripts that was part of their protocol and approved for how they would go through this process of offering, was a person interested, then going, if they were interested, to counseling about the variants that had tentatively been identified there. But in that research design, part of the ask was, do you want to give us a blood sample or saliva sample for CLIA confirmation? So it was a multi-stage process. So what I love about this question, Alex, is it recognizes that this is multi-stage. It has to be figured out all in advance. And you made reference to budget restrictions. Budget, budget, budget. You've got to get the budget to do it right, or you're going to end up in a terrible squeeze.
Karen has posted for everyone, please take a look at the chat, the link to the survey. I'm going to take the chair's prerogative with Professor Wolf's permission to share one more question. And those of you who are having to drop off, we're very pleased to have you here, and let us know of topics that you would like us to pursue at future Research Ethics Forum. So from another one of our genetic counselors, she notes that some investigators feel uncomfortable with the non-CLIA nature of the data, while the genetic counselors who are clinicians feel a strong duty to identify and disclose pathogenic mutations in genes on the ACMG list. There is also a huge effort involved in identifying the relevant variants and recontacting patients, and that alone is a huge barrier. I also very much appreciate the slide about the new paradigm in patient engagement. So do you have any comments on the conflict that the counselor was speaking to, which has sort of been at an intellectual level, the heart of your talk, but this is different groups feeling differently about what the right thing to do is and how to overcome those barriers?
Well, I think genetic counselors have an absolutely pivotal role to play in the whole process, as they do anyway in genetic and genomic research and clinical care. You know, by the way, it's pathogenic and likely pathogenic, as your genetic counselor will recognize. But, you know, if there is a divergence in view, then that, again, is all the more reason to get this straight in designing the protocol, in the proposal. And there's a lot of literature out there now that the questioner and his or her colleagues can use as fuel, because there's been greater and greater recognition up and down the line, including at NIH and other funders, and now modeled at major projects like the All of Us research program, that this kind of respect for people's informational preferences is really crucial. I go back to that sentence that I love from Zach Kohani's article, that really treating people as research participants and not just, as they called them, passive purveyors of biospecimens and data for that matter. I think we're already over that bridge, but making it real, and in part through return of results, is the challenge before us.
Do you think, just a final question, do you think that there are large numbers of people who are agreeing to contribute their material to the biobanks or otherwise precisely because they hope to have that information? And does that shape the performance of biobanks, or should it, in terms of communicating to people and raising that as a possibility and asking them how that affects what they want to have happen?
We do have studies now, empirical studies on expectations and preferences. So there are some data out there about this. Yes, I think some people are seeking that as a benefit, seeking the information. Some people with great sophistication, not because they think, oh, this is clinical grade information, but because they want to know, they may be interested in, as I said, donating their data for and participating in further research. So yes, I do think it's a motivation. Is it shaping some biobank practice? Yes, and research practice. Is that legit? I think it is, because I think that's part of saying, yeah, this is a partnership. Really? We couldn't do any of this research without these people.
Yeah. Again, many thanks, Professor Wolf, and we will follow up with your slides, the comments in the chat and so forth. All thank you, and I join in that. Everyone be well, have good holidays, and we'll see you in 2022.